Welcome to Georgetown and to our discussion, America's Misadventure in Torture, New Revelations and Hard Lessons. Thanks all for coming, and I want to thank especially Olivia Jallett and Tanya Weinberg for their efforts by way of administering this event, getting us set up, and spreading the word about this event. And I want to thank the Georgetown Law Dean's Office, the O'Neill Institute for National and Global Health, and the American University Washington College of Law Anti-Torture Initiative, and Georgetown's Center on National Security Law for their co-sponsorship of this event. The tattered flag in the graphic on the posters and flyers for this event actually does fly over Guantanamo Bay's Camp Justice. Camp Justice is where trials of the accused 9/11 plotters will supposedly unfold if the pretrial process of litigating the implications of these men's torture for the evidence that can be admitted plays out within the lifespans of defendants, witnesses, and lawyers alike. Meanwhile, details of the CIA's still largely classified torture program continue to emerge. Or more accurately, they're being extracted and pieced together through the indefatigable efforts of lawyers, journalists, scholars, and others who've resisted official efforts to employ classification as excuse for cover-up. The speakers at this event have been and remain amongst the nation's leaders in the effort to extract and assemble the story of America's misadventure and torture, to grasp this story's larger meaning and to learn and act on its lessons. Though many Americans, including some with leadership roles in government and national media, are under the impression that this story has been largely told, surprising new details have come out in the last few years, months, and weeks through the Freedom of Information Act, through the litigation brought by the ACLU against James Mitchell and Bruce Jessen, and via Mitchell's testimony just a few weeks back at Guantanamo Bay. We've long known about the torture program's origins in research into the psychological design behind Communist Chinese captors' so-called brainwashing of American POWs during the Korean War. And we thought we knew that Mitchell and Jessen, who we thought designed the torture program, relied heavily on University of Pennsylvania psychologist Martin Seligman's theory of learned helplessness in sequencing techniques of abuse so as to destroy detainees' resistance. We now know that CIA physicians, even more than we understood, played critical roles in the evolution of waterboarding technique, the management of prolonged sleep deprivation, the design of methods for throwing, methods and holds for throwing people against walls, and more. And that Mitchell and Jessen at least claim to have based their design of enhanced interrogation, as they and the CIA called it, not on the psychological concept of learned helplessness. In fact, Mitchell says he sought to avoid learned helplessness, but on the idea of classical or Pavlovian conditioning so that non-cooperation would trigger anxiety in detainees, followed by operant or Skinnerian conditioning to associate cooperative truth-telling with reward. And as we'll discuss during our panel, this could have implications for the 9/11 trial defense team's efforts to suppress statements made by their clients after torture. Beyond this, we now have reason to suspect, or at least to wonder, whether the CIA relied on, perhaps whether the CIA did not rely on, perhaps not even primarily, on Mitchell and Jessen. Whether, in addition or in parallel to the ideas of Mitchell and Jessen, the agency drew upon a still classified program of brutal interrogation that may have survived congressional efforts in the 1970s to shut it down. And we now know lots more about how the CIA and professional societies gave psychologists and physicians cover to disregard their long-standing ethical constraints so as to engineer oversee, and legally rationalize the torture program. The diverse roles of these psychologists and physicians were critical to the Bush administration's legal rationalizations for the program. Had these professionals refused to help to design and oversee the program, it almost certainly would not have gone forward. Certainly the legal rug from under it would have been cut out. Our speakers will address these and other revelations, their implications and lessons learned, or lessons that we should learn, from America's post-9/11 pursuit with torture. In so doing, they'll take seriously the importance of gathering accurate, actionable intelligence from captured actors who may have or know about plans to do our country and its people harm. They'll speak to science-based efforts to do this work and to the constraints that professional ethics and international law impose or should impose upon these efforts. Some of our speakers are constrained by law from telling you all that they know. They're bound by law on pain of criminal prosecution not to share classified information, even if they themselves want to share it, even if they themselves believe that no national security purposes are served by keeping this information secret. So I urge you all, when in our Q&A, to keep that in mind, even as you at the same time press them appropriately. Here's our plan for tonight. First, we'll show a few short film clips, 10 minutes or so from the documentary Eminent Monsters, a film by award-winning Scottish director Stephen Bennett that sets forth some of the history that led up to America's torture program. Then a few minutes from The Report, a film by Scott Z. Burns that depicts the Senate Intelligence Committee staffer Daniel Jones's lonely, persistent effort to piece together the story of the CIA's torture program, including Mitchell's and Jesson's role. In fact, as some of you may have read and learned, the two psychologists were originally going to be the film's main focus until Burns decided that Daniel Jones, who is here with us tonight, was more interesting. Then our speakers, you can Google their remarkable accomplishments. So I'm going to be beyond brief on the bio front, just to maximize our time. First, we'll have about 10 minutes of remarks by Dan Jones, and he, as I mentioned, is the former U.S. Senate Select Committee on Intelligence investigator who led that panel's years-long inquiry into the CIA's torture program, culminating in a 6,000-plus page report on the program. I have trouble beginning to imagine what it's like to write 6,000 pages or even to superintend the drafting of 6,000 pages. Only a small fraction of which, the executive summary, has actually been released to the public. The rest of which, some in the Senate and in the current administration, have actually tried to have all copies destroyed. Jones is also the founder of Advanced Democracy, Inc., and that is a nonpartisan, nonprofit investigative organization, and the Penn Quarter Group, which is a consulting research and investigative firm. Then we'll have remarks by Juan Mendez, who is formerly a UN Special Rapporteur on Torture and former America's Director for Human Rights Watch. He's now Professor of Human Rights in Residence at American University's Washington College of Law and Director of the Washington College of Law Anti-Torture Initiative, and he's superintending the development of an international protocol on non-coercive investigative interviewing. Then our panel discussion, I'll moderate, and I might try to slip in a few comments as well. I'm a professor of law at Georgetown, and I've been investigating and writing about the role of medicine and the behavioral sciences in human rights abuse abroad and in the U.S. for more years than I'd like to admit. Mark Fallon was formerly director of the Criminal Investigative Task Force at Guantanamo Bay, and he's the author of Unjustifiable Means, the inside story of how the CIA, Pentagon, and U.S. government conspired to torture. The Alka Pratam is Human Rights Counsel at the Guantanamo Military Commissions and has been a prominent, outspoken voice on the larger issues that the Guantanamo trials raise, and will be is also participating in Juan's International Protocol project. Susan Brandon was formerly the research director of an entity known as the High Value Detainee Interrogation Group, an interagency body created early in the Obama administration to develop evidence-based techniques for doing this critically important intelligence gathering work, and for doing it lawfully without invoking anything near what we did in the immediate wake of 9/11. And she's also a former White House staffer and a founding partner of Sync Science LLC. David Lubin has long been writing insightfully about the torture program and about the role of different professionals in it. He's university professor here at Georgetown. And he's the author of the book, which I strongly commend to you. As I do, I commend all books. I commend Mark's book as well. It is also a wonderful book. David is author of Torture, Power, and Law. Stephen Barella is the lead editor of Interrogation and Torture, which is a volume that came out, an edited volume that a number of us have contributed to, that came out just a couple of months ago. And he is senior research fellow at the University of Geneva. Those are our introductions. Let's go now to the film clips. So these clips frame much of what we're going to talk about today, including not only the CIA's interrogation program, but the efforts to prosecute the alleged perpetrators of 9/11. And that was not the real Dan Jones, but we have the real Dan Jones with us today, who will offer his observations and insights right now. And so I'm stepping out of the way.
Can immediately feel the disappointment that Adam Driver's not here tonight. Happens all the time. Thank you so much for having me here tonight to talk about this. This isn't what I do now, but it's something that will be with me the rest of my life, as it is with the panelists you'll hear today, because the topic itself is just so important. I thought I'd just give a quick overview of what the Senate report was and what its findings were, and then we can kind of dive into it in the Q&A with the folks that are here tonight. The Senate's report on the CIA's detention and interrogation program, it's the official name, otherwise known more informally as the Senate Torture Report, is about specifically the CIA's actions post 9/11. There's some confusion in so much as what did the Senate cover that perhaps maybe, what did the Senate not cover? Well, the Senate did not look at renditions, right? That was not something that was in our stated purpose to look into. We also didn't look into what the U.S. military was doing. This was exclusively looking at the CIA. The Senate report began with the revelation initially that the CIA had destroyed over 90 interrogation tapes at the very first detention site that they operated. These were tapes that were made in 2002. They were destroyed in 2005, and the Senate learned about the destruction of these tapes at the same time everyone else in the world learned about the destruction, through a news article by Mark Mazzetti, an investigative reporter with the New York Times, who wrote about these tapes being destroyed, and that the tapes were destroyed over the very objections of then the Bush White House, as well as members of the Senate who were initially briefed. There's one person or two individuals who were briefed who objected, as well as the Office of Director of National Intelligence. Eventually it came, there was an investigation into that, and it came out that two individuals who were most responsible for that destruction was a man named Jose Rodriguez and a woman named Gina Haspel, who is now our current CIA director. The investigation itself, again, began with the revelation of these tapes being destroyed. The objective for the Senate was to find out what would have been on those tapes. And the Senate chose to keep a very, I'd say, tight review of that issue, because at the same time, the Bush White House, the Bush Department of Justice, I should say, launched a criminal review. It was a criminal inquiry to see if someone at the CIA violated a law by destroying those tapes. So we, at the Senate Intelligence Committee, at the time it was Jay Rockefeller from West Virginia who was the chairman of that committee. He tasked myself and some other staffers with going out to the CIA and looking at these operational files, right? What we called cables. CIA cables are classified cables. And these were the records from the very first detention site that were sent back to CIA headquarters to inform them of what they were doing. It took about a year and a half for the staff of the Senate Intelligence Committee to go through, I would say probably it's about 20,000 pages of detailed reports that included the torture of 2 CIA detainees. The staff presented a summary of its findings to the Senate in February of 2009, and 3 weeks later, by a vote of 14-1, the Senate Intelligence Committee agreed that they needed to do a far larger investigation into the CIA's interrogation program, not just what was on those destroyed tapes from 2002, but to look at the entire program up until when it concluded with an executive order signed by President Obama. The report itself is, as mentioned, is over 6,700 pages. It's classified. It has 38,000 footnotes, almost exclusively to classified CIA documents. Again, our approach to this investigation wasn't to tell the entire universal story of how the U.S. began to use torture. It was really to tell the CIA story, because we had access to classified CIA records that we knew no one else would get access to, likely ever again. And those records were eventually, by the end of the production phase, ended up being 6.3 million pages of records. So it was pretty much A to Z in what the CIA had in their database. In December of 2014, we took this near 7,000-page report and consolidated it into a 525-page summary with 2,700-odd footnotes to CIA records. And that's the report you can find online. You can download it. It's a PDF. You can also buy it in a bookstore. And for the most part, I think that accurately conveys what's in the larger 7,000-page report. That 500-page summary has 20 findings and conclusions that the Senate drew from going through those 6.3 million pages. I want to talk about the one that I get asked about the most, and that is the effectiveness findings. The Senate found, after going through 6.3 million pages for nearly 7 years, and that without a doubt, the use of torture was ineffective. And people say, well, how did you come to that conclusion? One is we read all the interrogation reports, right? There were at least 119 CIA detainees, 39 of which the CIA acknowledges were subjected to what it called enhanced interrogation techniques. This is waterboarding, cramped confinement, sleep deprivation, et cetera. And we looked at those interrogation reports just to see output. But more importantly, before we did that, we looked at what the CIA themselves had said about the effectiveness of these techniques. And what we looked at was basically the 20 most frequent cases in which the CIA said, if not for the use of waterboarding or XYZ technique, we would not have learned about this terrorist operative. We would not have stopped this terrorist plot. Which was an easily verifiable task. It was it's something that was very objective. We could go through their databases and see how a plot was disrupted. And if you'll recall, in obtaining the legal approvals to use these techniques, and as well as talking about the effectiveness, the CIA said we must use these techniques because we cannot obtain this information in any other way. In other words, they called it, quote, otherwise unavailable intelligence, which means we could not learn about this plot without using the waterboard. We couldn't learn about it through going through someone's email. We couldn't go through it through non-coercive interrogations. We couldn't learn about it from foreign partners. We needed to do this treatment to this individual in order to acquire this information. And then secondly, the information that they acquired disrupted a plot or led to the capture of a terrorist, which in turn saved American lives. So this was, to me, a very graspable task. So we took those 20 most frequent success stories that the CIA had claimed, and we looked at them in depth. Was there otherwise unavailable intelligence that was produced, and did it matter in such a way that it disrupted a plot? And we looked at these 20 cases, including the capture of bin Laden is one of those cases, and in all 20 cases, we found that the CIA's claims were inaccurate. just to talk about two that are right off the top of my head that were frequent. One is Jose Padilla and a dirty bomb. This was a plot the CIA said an American citizen was obtaining training in Pakistan with Al-Qaeda, and he was going to basically explode a dirty bomb on the National Mall. And the CIA said, had we not used enhanced interrogation techniques, we never would have known about Jose Padilla, we never could have captured Jose Padilla, and we would never have been able to stop this plot to use a radioactive bomb in Washington, D.C. And it didn't take long to go through CIA records to realize that, in fact, none of that was accurate. Jose Padilla was detained in April of 2002, months before the enhanced interrogation program began in August of 2002. The first mention of Jose Padilla in CIA records came from Pakistani law enforcement sources. Pakistani law enforcement said, we have an American citizen by the name of Jose Padilla. We believe he's training with Al-Qaeda. And then finally, when we looked at the plot, the dirty bomb plot, this plot to irradiate the National Mall, it was based on a satirical internet article. So these facts were all very much laid before us, and it was obvious that enhanced interrogation techniques didn't play no role in the capture of Jose Padilla, and certainly played no role in saving lives. The other one I will talk about is a Karachi plot, a plot to basically commit an attack against an embassy in Pakistan. And it was the capture of two detainees the CIA claimed would not have been captured without the use of enhanced interrogation techniques. Again, it was clear it came from Pakistani law enforcement, not even Pakistani intelligence, it's Pakistani law enforcement. It was a referral, a criminal referral about a bunch of guys in a truck with explosives. And it was just normal gumshoe law enforcement, local level. Somebody called it in, local police found these guys, and eventually they called in the agency. And in all 20 cases, as I mentioned, this was just not accurate. And then when we moved on from those 20 cases, and it was clear that none of the CIA representations were accurate, we looked deep into the interrogation records themselves. And what we found time and time again, which you'll hear from the panelists today, I'm sure, is that coercive interrogation techniques produce false answers and unreliable information. And we saw that again and again and again. And what we're really fighting right now is a counter-narrative. You saw the Trump mention we should be doing worse than waterboarding. And the claims from the agency that these techniques were effective. But remember, their skin in the game is it was only legal, in fact, if it worked. So that you really can't go by those claims. You basically need to read the report. I would very much encourage you to go home and download it. It's a free download. There's a lot in there. People say there's a lot of new revelations that are coming out of Guantanamo. While that's true, I think there's a ton of data in that 525-page report that people have perhaps forgotten since 2014. But it's packed with information. And anyway, I hope you enjoy the panels today. Happy to take questions throughout. I think this is a really important topic, and I thank you for being here today to talk about it.
Thanks so much, Dan. And our next speaker, who I owe an apology to for not having a film to introduce him, but he's every bit as much the star, Juan Mendez, who is the former UN Special Rapporteur on torture. Thanks a lot, Juan.
Good evening. I am very grateful to Greg and to Georgetown University Law Center and its Center for National Security Law for giving us at American University and our anti-torture initiative of the Center for Human Rights and Humanitarian Law the opportunity to co-organize, co-sponsor, or just put our name to this very excellent event. The good news is that although torture in the global war on terror is a stain in the reputation of the United States, the issue has not disappeared from public consciousness despite the policies of different administrations. Public consciousness is still very much aware of the need to provide redress and accountability for what has gone on since 2001. There are good news, like the decision by the appellate panel of the International Criminal Court today reestablishing the jurisdiction of the ICC on war crimes and crimes against humanity committed in Afghanistan. And as we will discuss later, there are revelations from the past weeks in the military commission's hearings that have been taking place in Guantanamo, precisely about one issue that some of us would have thought was very well settled: the application of the exclusionary rule to all evidence obtained under torture. And yet we're still debating it. But as we debate it, we get excellent new revelations and reasons to continue to advocate for accountability for all of this. This event is also the opportunity to launch the book Interrogation and Torture. And it's great to have here amongst us some of the editors and some of the authors of different chapters in that book. I'm again proud to have been given the opportunity to contribute a chapter to Interrogation and Torture that I wrote jointly with my colleague Andrea Nicolescu. The chapter and what I'm going to share with you today is the need for a protocol on non-coercive interrogation. In my experience as a special rapporteur on torture between 2010 and 2016, I came to realize that torture happens in many, many different countries, including highly developed countries, and that it mostly happens in those initial hours after detention with the purpose of obtaining confessions or obtaining evidence to solve crimes, quote unquote. And it's in that kind of setting that we need to substitute what we have now for practices that contribute to solving crimes by applying principles of a professional, ethical, lawful, and dignified way of investigating crime. In fact, the international law prohibition on the use of torture in those circumstances and in all other circumstances is very clear. What we don't have is an alternative to torture for that opportunity in which it happens so often in the interrogation immediately following detention and before the person is brought before a judge. And at the same time, there are best practices. In some countries institutionalized, and in other countries, even where torture is still practiced, it is the best practice of professionals who know the business and understand the pitfalls that torture brings to investigation of crime. And those practices need to be universalized. They need to be made into international standards that all security forces and all investigators should apply on a daily basis. The process of drafting such a protocol has begun, and many of us have joined together to create a steering committee that guides this process, a drafting committee that kind of produces from time to time different versions of what will eventually become this protocol, and an advisory council now counting more than 70 experts and from all over the world who are assisting us on this. The process also has the support of the current mandate holder of the Special Rapporteurship on Torture, of the chairs of the Committee Against Torture and of the Subcommittee on the Prevention of Torture, and of the United Nations Voluntary Fund for the Victims of Torture. All of the United Nations entities that specialize on the combat against torture are supporting this effort. And so have the General Assembly and the Human Rights Council in several resolutions that have been passed. But of course, that support for the idea that we need a protocol. What the process has been consisting of is essentially an expert-driven process by which people who have understood the worth of this idea have come together to make it happen. The experts that I'm talking about consist of, first and foremost, police and security forces professionals who have seen what torture produces and who know better and can explain why a more lawful and ethical and professional way of investigating crime produces much better results. The effectiveness standard that Dan was talking about only a few minutes ago. But it also includes jurists and academics and legal advocates and human rights advocates from around the world. It includes criminologists and medical doctors, psychologists, and psychiatrists who have long studied the effects of torture on investigations, and obviously the negative effects on the dignity of the persons who are subjected to it. After 2 or 3 years of work, we have produced several meetings of these different bodies that I mentioned, and we are currently completing the 5th draft of what will become a protocol. And this final draft that I expect to be able to present to the international community sometime in the middle of this year. The draft will contain, first and foremost, safeguards, restating the legal safeguards that international human rights law imposes on this kind of investigation of crime, but also safeguards that are drawn from the experience of non-coercive interrogation, because the purpose is to offer, as I said, an alternative to the brutality of torture that is not only more lawful and more ethical, but also much more effective in fighting crime. It will be basically the minimum standard of professionalism and for respect for human dignity that is necessary to uphold. It will hopefully enhance not only the effectiveness of non-coercive interrogation, but also the legitimacy of institutions, of police forces and investigatory bodies around the world, because it will not only make them more professional, but they will eventually enjoy the public trust that these institutions need to be effective in the fight against crime. But eventually this will become a soft law instrument, similar to very well known and very well established soft law instruments like the standard minimum rules on the treatment of prisoners, now called the Nelson Mandela rules, or the Istanbul Protocol for the detection and documentation of torture, or the Minnesota Protocol on how to investigate extrajudicial executions. We aspire to have a protocol that will offer valid alternatives to torture, and that I think will be very much enhanced by this book, Interrogation and Torture, that will contribute very sound scientific and legal knowledge to this struggle for the abolition of torture in our time. Thank you very much.
Okay, and now we'll begin our panel discussion. And will our panelists please come on up to your appointed spots. Looks like somebody doesn't get a water bottle.
Oh, I brought mine.
Ah, good, good. I'm going to take my appointed spot. Looks like I got a water bottle. And I've done the introductions, and I apologize to some of you for being so brief, but we have so little time, brief with the introductions, but we have so little time. And so why don't we go perhaps in the sequence by which our wonderful event presenters, planners have laid out the cards. Is that okay with everybody?
Sure.
Okay. And so the concept is each member of the panel will offer perhaps 3 or 4 minutes of introductory remarks, and then we will go to discussion and Q&A, and then the floor, at that point, the floor and the discussion will be yours, and we look forward to that. And at that point, once we get into the discussion period, Juan and Dan will come up and join us. So go ahead, Alka.
Okay. Well, thank you very much, Greg, for the invitation to participate. My name is Alka Pradhan, and I am counsel for a detainee named Ammar al-Baluchi at Guantanamo Bay. He's been there at Guantanamo Bay since 2006 and was held prior to that for 3.5 years in the CIA, in CIA black sites, a number of black sites. I have to start off by saying I am an employee of the Department of Defense, and so I have to issue a moderate disclaimer that nothing I say ever reflects the opinion of the Department of Defense. And nothing I say should be taken to confirm or deny any information that the U.S. government considers to be classified. And so that reflects what Greg said earlier, and that includes for example, the locations of the black sites. The Guantanamo military commissions are a topic that are not easily covered in a couple of minutes, but I'll do my best. Ammar is one of 5 defendants being tried jointly in what is generally called the 9/11 case at Guantanamo. We have been in pretrial hearings for nearly 8 years, and the reason for that is the CIA torture program. And so I'll start off with basically a bit of background about what exactly happened to these men. So Ammar himself was picked up in April of 2003 and was held, as I said, for 3.5 years at the black sites, during which he was subjected to just absolutely brutal torture. And for those of you who may have seen the film Zero Dark 30, the detainee tortured in the first 20 minutes or so of that film is Ammar, and the things that are portrayed as happening to that detainee actually happened to Ammar. So he sustained a traumatic brain injury at the hands of the CIA, pursuant to his walling. He was tortured with water on a tarp. Rather than waterboarding, he was water doused. He was sleep deprived for days at a time. He was subjected to standing sleep deprivation for days at a time. And after that, they subjected him to several years of psychological torture, including constant lights in his cell so that he could not sleep, loud music, death threats, etc. And so in September 2006, he and the other so-called high-value detainees, which is really just a euphemism for the detainees who were held in the CIA program, were brought to Guantanamo with the stated intention of prosecuting them at this point. And the government decided, or realized really, that they had a problem. And this is a reference to what Juan mentioned earlier as the exclusionary rule. Because these detainees had been tortured for several years, the statements that they had made during those years of being disappeared in those black sites would probably not be admissible in a prosecution. And so what they decided to do, and by they I mean the entire US government, because this was not just a CIA plan, it was not just a Department of Justice plan, it was a whole government program. What they decided to do is reinterrogate these men at Guantanamo a few months after they were brought. And instead of CIA interrogators, they brought in FBI agents, special agents from the FBI, to ask these men essentially the same questions that they'd been asked for several years under conditions of acute physical and psychological torture at the black sites. And those statements that they made in January of 2007 are the statements that the government is relying on as their primary evidence against Ammar and the other detainees at the military commissions. Now, for a very long time, for actually the entirety of the 8 years of pretrial hearings, we, the defense counsel, have maintained that there is no way that the FBI agents who interrogated Ammar in January 2007 had no prior knowledge of what he had said under conditions of torture at the black sites. There had to have been a continuum. And what we found out was that it was actually much worse than that, that the FBI agents who interrogated Ammar in January 2007 had in fact been involved in his interrogations at the black sites. They had sent questions to be asked of him at the black sites. They had taken his answers and had incorporated them into the 9/11 investigation. When you read the 9/11 Commission report and you look at footnotes that refer to detainee reporting, that is detainee reporting from the black sites under condition of torture. And so under any objective standard, those statements that were made in January of 2007 would be subject to the exclusionary rule, would be dropped from the case. The government is fighting very, very hard to keep those statements in because they form, as I said, the primary evidence against these men. And so we are in the process of a series of suppression hearings in the 9/11 case to try and suppress those statements at trial. As part of those suppression hearings, we took testimony in January from Drs. Mitchell and Jessen, the two psychologists who came up with the initial list of torture techniques to be used on these detainees at the black sites. And there's been a great deal of reporting about Dr. Mitchell's testimony, and we had one day of Dr. Jessen's testimony. But in a nutshell, Drs. Mitchell and Jessen confirmed all of the gory details, some of which you've heard about today. When Dan's character in the report talks about 183 incidences of waterboarding, Dr. Mitchell wanted to clarify that that was just 183 pours of water. It wasn't 183 different days on which Mr. Mohammed was actually waterboarded. So those sorts of distinctions were drawn to great outrage, at least on our side in the courtroom, over the course of 2 weeks at Guantanamo in January. We will continue testimony from Dr. Jessen later this year. But there are sort of four, and I know that I'm closing in on my time, but there are sort of four points that I want to leave you with. The first is that clearly the basis of the government's case against these men is torture acquired and should be excluded. The second is that during this time, during these 8 years of pretrial hearings, and even before that, there has been a systematic dismantling of the presumption of innocence against these men. And that was, you don't have to take my word for it as defense counsel, that was recognized and concluded by the UN Working Group on Arbitrary Detention in an opinion 89, 2017, on Ammar's case that is available online. The third is that the classification of the government's torture program remains an enormous problem. Dan has done absolutely heroic work in getting the summary released, but I will tell you, I hold a top secret clearance, and the summary is all I have access to. I don't have access to the full report, and never have. And so, and I actually speak from a unique place of rage on this tonight, because immediately before I came here, let me back up. In my preparation for the cross-examination of Dr. Jessen, I asked the government to review and declassify a document that has enormous detail about Ammar's torture, including viewpoints of from the people who tortured him. And I was given an unclassified version of that document to use during my cross-examination of Dr. Jessen, made reference to it in the courtroom, and submitted that in a notice of exhibits. And that was supposed to be posted to the website. And I looked at what had been posted to the website immediately before I came here, and every single page of that document has been blacked out. And it's an unclassified document. And so this is what we're dealing with 8 years into pretrial hearings. And so when you wonder why we haven't had a 9/11 trial yet, or whether we can ever have a real fair trial for 9/11, that's what I would like people to keep in mind. And another thing that I'll talk about, if there are questions about it, is just the fact that these men are still very much suffering from their torture and have never had proper torture rehabilitation or treatment at Guantanamo.
Thank you, Alka. David.
Hello. In my few minutes of remarks, I'm going to be drawing on a paper that appears both in the Interrogation and Torture volume and also in the Georgetown Law Journal. I wrote the paper together with Catherine Newell, and who was here earlier, but, oh, there you are, thank you. Catherine is the Resource Council on Detention and Interrogation Issues for the Military Commission's Defense Organization. I want to start very quickly telling you what torture is under law, under U.S. law, also under international law, although the definitions are different. The essence of what makes an act of torture is that it's an act that is intended to inflict severe mental or physical pain or suffering on the person who is being tortured. So a lot of the legal debates in the torture memos were about how severe is severe. All of these debates, I mean, the memos go through what began as 10 enhanced interrogation techniques. Eventually, it was 13 enhanced interrogation techniques, asks the question of each of them, and concludes that that is not severe. One of the torture memos says, what if they're used in combination with each other? And it concludes that that also is not severe enough. Now, what we think is that the focus on individual enhanced interrogation techniques is really a misplaced focus. And you can see this from the films. Just as important as waterboarding, episodes of sleep deprivation, wall slamming, the list of techniques are the 24/7 conditions of confinement. Alka mentioned this as well. Light all the time so that you can't sleep, or darkness all the time. Foul smells that come from not having the toilet buckets emptied. Threats, manipulation of diet, manipulation of temperature, and so on. So 24/7. Now, this is experienced by a prisoner holistically. I mean, they don't care whether whether the particular abuse that they are undergoing is on the checklist or not. So it seems entirely plausible that the entire pattern of action inflicts severe mental or physical pain or suffering. Now, that's important. That kind of holistic understanding is important because it is exactly what the decades of CIA research that were described in the first film clip concluded. It was about a total pattern of control of a person. The program went by the code name MK Ultra. It was a research program conducted by many psychologists under contract in more than one country. As I say, for decades, it was boiled down into a manual codenamed the Kubark Manual. It was also turned into a pair of manuals called Human Resource Exploitation Manuals that were used by U.S. personnel who were training security forces in allied countries, mostly Latin America, for years. Now, there was a kind of disconnect in the film between these decades of CIA research and now Doctors Mitchell and Jessen come in and start teaching the CIA what to do. How do we explain that disconnect? The CIA's official story is that all of the Kubark material and MK Ultra material was lost lore. And the program had been discontinued years before, and we didn't know how to do it, so we brought these contractors on. Now, it turns out that this is untrue. One of the kind of most powerful pieces of evidence is that the chief of interrogations of the renditions group, referred to as redacted in the report, Mr. or Ms. Redacted, was also someone who had been involved in teaching the Human Resources Exploitation Manual in Latin America. and in fact had been reprimanded for having abused these techniques. But this isn't the only point of continuity. There were CIA cables that show that there are other interrogation experts at the CIA. There were psychologists in the Office of Technical Services who were experts on interrogation. And just commonsensically, do you really believe that the largest intelligence agency in the world didn't have anybody on the staff in 2001 who was an expert in interrogation? And do you really believe that two walk-on contractors are brought on to lead one of the most sensitive programs that the United States counterintelligence community has ever conducted? It's simply not plausible. I think if I have one critique of the film, the report, it is when the two psychologists are briefing CIA officials as if this is news. It wasn't news. Now, that's important. When one of the other pieces of the history is that the MK Ultra program became the subject of an enormous scandal when it came out, beginning with the Church Committee in 1975, but there were many Senate investigations, and it was in part because one of the aspects of the program was dosing unknowing and involuntary subjects with LSD and other psychotropic drugs. One of the most famous instances involved the person who had been dosed eventually committing suicide, diving out a window. There have been allegations of homicide as well, but that's beyond my competence or remit to discuss. So this was an extraordinary scandal. When it came time to draft the U.S. Torture statute, which implements the Convention Against Torture, which we joined in 1988, Congress inserted one piece of the definition of mental torture. Now, the debates about severity, how severe is severe, were all about physical torture. It turns out that the U.S. statute actually has a definition of what counts as severity for mental torture, and it is prolonged pain or suffering that is caused by the administration, here I'm quoting the statute, or application or threatened administration or application of mind-altering substances or other procedures calculated to disrupt profoundly the senses or personality. Now, all of these years of research supply the element of calculation. It doesn't matter what you call the scientific theory on which the interrogation program was based. Learned helplessness was one model that's been discussed. Regression is the name that was given in the human resource exploitation manuals in Mitchell's testimony at Guantanamo. It's, as Greg mentioned, Pavlovian and operant conditioning. All of them show the calculation, and all of them have as their goal, their intention, the profound disruption of the personality, namely taking away the subject's free will, making them into somebody who will comply over the course of weeks and months of interrogation, which supplies the prolonged element. So one conclusion is that what was done was not only illegal under international law, which is, those of you who study international law know is not accepted in U.S. domestic law unless the U.S. has specifically implemented it. Well, we implemented it. We implemented it in a statute that was designed to rule out exactly what this program was. So that's, that is the argument. So let me just quickly say what I think the headlines are. First, we shouldn't be focusing on EITs. That is asking the wrong question about the individuals. It's like this children's classic that I used to read to my toddlers back when they were toddlers called Who Sank the Boat, in which a bunch of farm animals get on the boat one at a time. And who was it who finally sank the boat? Was it the sheep or the cow or the last one to board, the tiny little mouse? Well, even a toddler knows that that's the wrong question. The question is, what about all of them together? Did they sink the boat? All of them together, under the statutory terms that Congress wrote in, particularly to ward off this kind of abuse, pushed it over the line into severe mental pain or suffering. That is, under U.S. law, it was torture. So, thanks.
Thank you very much, David. Mark?
Yeah, thank you, Greg. And I want to thank our first speakers, Juan and Dan, for coming out and doing a great job. I was having dinner last night with Alberto Mora, the former General Counsel of the Navy, and Dave Brandt, the former Director of NCIS, and Mike Ellis, the former Chief Operational Psychologist for NCIS, who were kind of on the ground there in 2002 when this program was migrating to the Department of Defense from the CIA. And shout out to Alberto. Thank you for coming tonight, one of my heroes, sitting in the back of the room here, and who wrote the afterwards of Interrogation and Torture. So thank you, Alberto. But you know, it was a really unique time for us all. We had been attacked. We had 3,000 people dead. I had been working for the year prior to that as the commander of the USS Cole Task Force, investigating that attack. And I felt, frankly, the weight of the world on my shoulders as the chief investigator for a process that was supposed to bring terrorists to justice. And when I first heard that process, I thought, what an amazing thing. This is going to be an incredible process where we're going to show the world that we can fairly and justly bring our adversaries to justice. And when I heard that we were going to use Guantanamo as a site, I thought, what a great idea. I don't have to send my agents into Afghanistan, into a war zone. I knew there was a courtroom there. I had been at Guantanamo before during the Cuban and Haitian refugee crisis. And I thought, you know, there's a courtroom there. And I just thought, what a remarkable country we would be showing the world what this process is and how quickly that unraveled. I had no idea or concept that by November of 2001, the CIA was already talking about torture, was already talking about committing war crimes. And those documents have now been released, and they're actually on the CIA's website in November of 2001, where they're talking about torture and how the international community would not hold us to account if we could show we save lives. And that's the whole argument that Dan had mentioned, this effectiveness argument. That is part and parcel to the whole theory that has unraveled over the years on the CIA and the DOD, who were involved in torture. So in 2002, September 25th, a plane load of lawyers came to Guantanamo, and I had no idea of the extent and involvement of the CIA's program at that point. But the lawyers were Alberto Gonzalez, was President Bush's lawyer, and David Addington, Dick Cheney's lawyer, and it was Michael Chertoff, Deputy Assistant Attorney General, and it was Jim Haynes, who I was reporting to, the Office of Secretary of Defense, who I was actually detailed to the Army to work for the Office of General Counsel to bring terrorists to justice. And I thought I'd go down there and tell them how they do not need to go down this road of harsh, they were calling it harsh techniques. I didn't realize that harsh meant torture at the time. And I was not allowed to see those lawyers. I was denied access to those lawyers. As the chief investigator for this process, reporting to Jim Haynes, who was with them, I was unable to get into Jim Haynes, who was my boss at the time, and tell them my position as the chief investigator of this process that was supposed to conduct these investigations for these military commissions. And by October 2nd, a CIA lawyer came down and said, if a detainee dies, you're doing this wrong, and explained what the program was. And at that point, it was a quandary for me. And I went to Alberto Mora through NCIS, and we tried to put a stop to it. What I think is important about the interrogation and torture volume, what I think is important about what Juan Mendez talked about with the steering committee on this protocol on non-coercive interview and interrogations is that in those arguments that we talked about last night, Alberto, in those policy battles, had I had research, had I had what is available today, I may have been able to make a more convincing argument that may have diverted this course of history that we were on. But it was my word against the CIA's word, and it was the CIA saying how effective the things they were doing were. And so we went down a road now where the International Criminal Court is actually looking at, it actually has agreed to open investigations on crimes in Afghanistan, which will lead back to the Department of Defense, will lead back to the CIA, will lead back to Guantanamo Bay. And so a process that I thought had so much hope for me became one that was so hopeless. And until we bring people to account, until we come to grips with the stain on our Constitution, the fact that we were a state sponsor of torture, we committed war crimes, and until we do that and come to grips with that, justice will never be served. So, thank you.
Thanks. Thanks a whole lot, Mark. And Susan.
Thank you, Greg, and I appreciate the program opportunity to speak with you today. Forgive me for reading my comments, but I'm trying to be very efficient with my allotted time. As noted, I served with the High Value Detainee Interrogation Group, or HIG, from 2010 to 2018, during which time I set up and managed a research program on how to elicit information from someone who may be unwilling to tell their secrets. To disseminate that research, we created a one-week HIG training course on effective, science-based, and ethical interrogation techniques. What became apparent in setting up these programs was that there was and is a robust community of scientists, mostly psychologists, who had been conducting research since the 1980s on effective, rapport-based interview methods. Over the decades, we, by that I mean the American scientific community, had accumulated significant knowledge on how to build and maintain rapport, elicit details about past events or planned future events based on how memory works, persuade someone to cooperate using principles of social influence, and how to communicate effectively with a resistant subject. None of these were secret. Some could be seen in commercial advertising. Others could be seen in multiple attempts to convince American police departments to abandon their accusatorial techniques, interrogation techniques, in favor of rapport-based information gathering techniques. So we might wonder why the CIA's interrogation program was set up in a manner not only oblivious, but also contrary to this science. For one, it appears that James Mitchell and Bruce Jessen, two clinical psychologists steeped in the culture of SEER training, were either ignorant of such research or, more likely perhaps, vulnerable to what I believe is at the heart of the adoption of abusive interrogation programs: the belief that psychological resistance can best, or at all, be overcome with pain, fear, and deprivation. That's what the SEER training was about, after all. And that once such resistance is overcome, secrets will spill out as if we can squeeze them out. But these are separate processes. Pain makes people compliant and willing to do or say whatever is necessary to stop it. We used to spank children to punish them for their misdeeds or resistance. Now perhaps we send them to timeout, isolation, for the same reason. This is not, however, how to make children kind, honest, generous, or courageous people. For that, they must be nurtured by people they trust. The same is true for telling secrets. This is counterintuitive, however, for most people now as it was in 2002. I'm sure that if the U.S. is attacked again as we were in 2001, and I went to policymakers with all the knowledge and experience of the Hague research and training programs, that they would dismiss me as naive, that any failure to get interrogation from a person that those policymakers thought had critical knowledge would be followed by an insistence that we abuse them again. Thank you.
Thank you. Thank you very much. Thank you very much, Susan and Stephen.
Excuse me. Let me begin by thanking the organizers tonight. I'm very humbled and honored to be on the panel here this evening with this unsurpassed interdisciplinary expertise, and I'll do my best to keep up. So, my intention is to speak to you today about the new publication, Interrogation and Torture, Integrating Efficacy with Law and Morality, and in doing so, offer a background to the initiative that's been described by Professor Mendez. And the final chapter of the book, in fact, concludes with the chapter written by Professor Mendez and Andra Niculescu, and that's not a coincidence. Many of us in the book are working together to help Professor Mendez with this initiative and the large group that he's been able to assemble to push this thing forward, and we have a lot of belief and promise in this protocol that's being put together, and it's meant to be the conclusion of this large work. The work is meant to move towards a future without interrogational torture. One mention I'd like to make as well, or I'd have a few here and hopefully be able to keep them in the time frame I've been given, is that the foreword of the book was written by the current UN Special Rapporteur on Torture and Cruel, Inhumane, and Degrading Treatment or Punishment. That's today Nils Melzer. And just like last week, Nils Melzer issued a report to the Human Rights Council. And in fact, in that new report, it's on psychological torture. And unsurprisingly, he cited the excellent chapter by Professor Lubin and Catherine Newell. And so we were very pleased to see that citation in there. That's the chapter 2 in this volume. And I'm very pleased that Professor Lubin is up here on the panel with me to give more detail and explanation about how important it is to not focus on the ideas of the EITs, the physical aspects of the torture, but instead shift to the mental aspect, that was in fact trying to disrupt personality. Now, as far as the background to the initiative from Professor Mendez, I would suggest that we can look to the entirety of Part 2 here in the volume. Part 2 of the volume is about the emergent science, and that's really part of the impetus behind the book, was to bring this new science on the most effective interrogation techniques, which is about building rapport and trust with the detainee, and bring that into dialogue with philosophers and jurists. And so this whole Part 2 gives you a taste, gives jurists and philosophers a taste of this new science and an introduction to the scientific research. We have a chapter from an Irish neuroscientist from Trinity College Dublin, Professor Shane O'Mara, on torturing the brain, explaining what exactly the EITs do to the brain to damage the brain and make it impossible to recall information that was once known. We also have a chapter from an international group of authors on developing trust and rapport, trying to move the science forward and explaining how is it that alternative that Professor Mendez was talking about, what is the alternative, how does that work, how do you exactly build rapport with the detainee, and how that works to bring about the most accurate and reliable information from someone. In addition, we also have a chapter from an English psychologist and a Norwegian police detective, who are both on the steering committee for the Universal Protocol, and they have been involved. They write about the active practice of investigative interviewing that actually has already been taking place for the last 3 decades in England, and then has migrated to Norway, and they've been putting together efforts to make it move beyond that as well. In addition, we have the excellent chapter from Dr. Brandon and Mark Fallon that is about the Hague Project, explaining what the high-value detainee interrogation group, the Hague, is meant to do, has been put together to do, and we have the first chair and the first director of that Hague program, and talk about the road to scientific research on interrogation. Now, excuse me. I would be remiss to not put a bit of a spotlight on my co-editor and friend, Mark Fallon. He's been at the center of this work for years. We have seen some of the details about what he did when he was the deputy commander of the Criminal Investigation Task Force at Guantanamo. We saw his courageous actions at that time, and I would suggest you look into his book, Unjustifiable Means, to get a greater detail of what all he's been able to accomplish, what he did at that particular moment. But even since then, he hasn't stopped. He's been a force of nature ever since that moment. And that experience in Guantanamo had a profound impact on him and his team. One thing I can point to is the behavioral scientists on that team, the CITIF it's called. The behavioral scientists, 5 of the members of that team, in fact, were involved with a study that was put together, and first part was published in 2006 called Educing Information. And that study established one particular thing because, as I say, Mark Fallon, he didn't have the evidence he needed. He didn't have the documentation he needed at that time in Guantanamo to try and push back against the migration of torture. And one of the things that first needed to be established is that they had nothing to turn to. They had no science to turn to, and that Educing Information was first about establishing that there was no scientific studies specifically on how to elicit accurate and reliable information from anyone. And so that was the first step. And once that first step had been laid, President Obama picked it up, knowing that there had been no research, and that on his second day in office, we often talk about the Executive Order 13491 that Obama signed to take away the legal validity of all the OLC memos. And one of the other things that was done in that executive order was also to lay the groundwork for the Hague program. And as I said, Mark Fallon was the first chair of that Hague program, and Dr. Brandon was the director of that program for the first 8 years. And finally, I can say that Mark Fallon today serves on the steering committee for the protocol for Professor Mendez. And so Mark Fallon has been all over the place on this. As some people have said, he's the Forrest Gump of national security. I think he's far too suave and debonair for that description. But if I may, just to finish up, I'd like to try and bring this full circle, if I may, and draw attention to the chapter in the book, Chapter 3, from Darius Rejali. Many of you probably are familiar with the award-winning book from Darius Rejali, Torture and Democracy, and in fact was described in their chapter by Professor Lubin and Catherine Newell as a magisterial work, and I would agree with that. And Mark and I actually traveled quite a bit to talk with Darius Rejali and tried to bring him into this project and try and give him good reasons to participate. And in the end, he finally did bring an update, which I think is an excellent piece of work to take a look at. And one thing I want to do just to finish up here is to bring a quote to his original work, the book that he wrote in 2007, to try and bring this full circle. And that is, he wrote, "There may be secret, thorough reports of torture's effectiveness, but historians have yet to uncover them for any government. Those who believe in torture's effectiveness seem to need no proof and prefer to leave no reports." And for that reason, I would like to just take a moment to thank Daniel Jones for his heroic work and what he's done, because I think this report is of historic significance.
Thank you, Stephen. I'm going to briefly play a role as a panelist and offer some quick thoughts about the ethics of the physicians and psychologists involved. This program, the torture program, couldn't have happened without the pervasive involvement of psychologists and physicians. There was chaos and confusion that enabled this involvement. Ethical chaos and confusion all over the place. At CIA, there was a combination of and I talk about this in my chapter, my contribution to interrogation and torture. I will be brief. At CIA, there was both confusion and dismissal of the importance of ethics of the professionals involved. When some folks within CIA raised concerns about the psychologist, the agency early on turned to an old CIA hand and consultant, Mel Gravitz. As an ethical consultant, he opined that involvement in enhanced interrogation was beneficent, since it would produce the greatest good for the greatest number. The Office of Medical Services chief, we learned a year and a half ago, said that physicians and psychologists needn't worry about ethics, since CIA secrecy would protect them from getting caught. At Guantanamo, a few weeks ago, Dr. Mitchell said there's no ethical problem. There was no ethical problem since he was acting as an interrogator, not as a psychologist. The Psychology APA, the American Psychological Association, issued a statement on this topic back in '05. And in essence, it said, this statement said, don't participate in torture, but the Bush administration has redefined torture. So what we think CIA and Defense Department psychologists are doing, we don't really know, but we're not really going to ask, is not torture. So, again, no problem. And psychiatry, the American Psychiatric Association, did issue a statement saying we're opposed to all personal participation by psychiatrists in all of national security interrogation. Some of us would view that as way too broad. But this is a policy statement, not an ethical position, so we won't enforce it. So again, no problem. The result of all this, once these ethical dodges were revealed, was outrage and distrust. And I submit that that outrage and distrust afflicts today's efforts to formulate science-based national security interrogation strategies. A process of formulating guidance for science-based interrogation is going to need to take this distrust into account. And it will need to include a public, high-visibility process of negotiating ethical parameters and balancing urgent and competing ideals and concerns. Let's turn to discussion and Q&A, and since time is short, I suggest we open things directly to audience questions. And will Dan and Juan please come on up? There were rumors that a second chair was going to be made available. That seems not to have happened. I'll stand up.
I am happy to give up your place.
There we go. We, Georgetown folks, we can, we forced standing will work for us.
I am also happy to get up for the record.
Fine.
Georgetown folks are standing.
Yeah.
Yeah.
Okay, and through the bright lights, let's see. There we go. Okay, and if you could give your name and a brief institutional or other identification, that'd be great.
I can.
And same with everybody who asks a question or offers a comment.
I can. I'm Maria Hardwick. I'm a professor of psychology at John Jay College of Criminal Justice. I've been part of the Hague Research Program under Susan's direction. I've known Mark for a good while. I am a psychologist. I'm ashamed of the stain that these particular psychologists have put on my profession. That's one thing. I hear a lot about psychology and the nefarious influence of these psychologists. These are fringe people, first of all. I don't know where they came from, and I think they should go back to where they came from. This is naive, not particularly legally compelling arguments, but they're not part of our psychological community. There is a psychological community that takes seriously the question of what now? Because the fact that these are factual statements. Who can deny that these are factual statements? I challenge anyone to question the fact that America has engaged in torture. The question is, now what? And while I think it's absolutely imperative to retrospect, we also have to prospect and wonder, what do we do now? And I hear a lot about rapport building, which is very nice indeed. But rapport building doesn't tell you that much about what to do in an individual case when you are an interrogator and you're facing a source. I think what needs to be done is a kind of agenda where you give hands-on tools for the practitioners.
So let's ask the panel to turn to your comments. And does anyone on the panel have some thoughts?
Yeah,
Mark.
I do, Greg. And thanks, Maria. It's really, I want to emphasize what a critical time it is right now to answer those questions that Maria has posed. Not only is there this steering committee effort where we're trying to come up with a universal protocol That answers that question, because if not this, then what? Right? We have to protect the public safety. We have to protect national security. What the research tells us is that the best methodology to do that is with human rights compliant, non-coercive methods. And the timing is critical now, because right now in the U.S., the Army Field Manual is finally going to be reviewed. Some of us who lobbied for the release of the report, and thank you, Ms. Massimino, for attending, the former Executive Director of Human Rights First, who brought a number of us together to try to ensure the report got out, and interrogation professionals together to try to lobby on Capitol Hill and go door to door with Alberto Mora and Tony Taguba, talking to senators, telling them why these things are important. But the Army Field Manual is the Bible, the guide for soldiers and a lot of military personnel to utilize. And it is not based on science. It has a lot of coercive methodologies to it. When those of us lobbied for the McCain-Feinstein Amendment to be passed, it was under the provision that the Army Field Manual must be reviewed, because there's an Appendix M that has isolation, and it has a lot of those same things that David talked about, that you saw in Eminent Monsters about isolation and sensory deprivation. It has a lot of those things in it. So that is ongoing right now. The President has established, under the Attorney General, a National Commission on Law Enforcement and the Administration of Justice. This is the first time since the Lyndon B. Johnson administration that we've had such a commission. The time prior to that was under Herbert Hoover, with the Wickersham report came out, which did away with the third degree, which did away with those abusive interrogations. And reading the Wickersham report, we found out they used the water cure back then. Police departments in the U.S. were using the equivalent of waterboarding back in the 20s. And so right now, it's a critical time for us to ensure that we are getting the message out. Not only, and I don't want to demean what's lawful or human rights compliant, it has to be, but the nice part is what's effective is these non-coercive methods. And so it answers that question, and I've gone around, and I also want to highlight Rebecca Schaefer, an alum from Georgetown, who's also on the steering committee. We've gone around the world, and I've spoken to police in Tunisia and in Thailand and Brazil, and they want alternatives. They're looking, we don't want to do this, but what do we do? And so, Maria, that's what we have to answer. That's what researchers and practitioners need to get together and ensure that we're getting the word out about these new processes so that we are doing better.
Yes, and you are? In the blue shirt, yeah. Oh, I didn't see, so both of you in sequence, if there were two of you. Oh, okay.
Oh, well, jolly good. I'm Matthew Davis. I'm a first-year law student here. I was kind of two questions. One, given the need for efficient information directly following 9/11, and presuming that the CIA knew about the effectiveness of torture, the ineffectiveness of torture, the cost, and the reputation risk to it, I was kind of curious as to what you view as the motivation to pursue the program, and what kind of institutional decisions may have led to that. And second, what do you view as necessary in our country to allow the proper oversight and the proper culture to develop to prevent this from happening, or what lessons can we learn from what did happen to prevent a similar situation from developing again?
Are you directing that to me?
How about, Dan, do you have any thoughts about that first question? And Susan, perhaps, on the second one to start things off.
Sure. I think the first one was, how did the CIA go down this road, knowing what they knew? Is that correct?
The motivation.
Yeah, the motivation. I think one of the other panelists mentioned earlier, of course, the CIA knew that this doesn't work and it's ineffective and this continuation. I would just say, based off the written record, I wouldn't agree with that. If you've worked in a government agency, the government agency may in fact know something, but the individuals within it may not recall that. Particularly, I worked at the FBI, a place where people come in for a position for 18 months, 24 months. You're doing bank robberies, and then you're going to be doing drugs, then you're doing Al-Qaeda, and then you're doing something else. And while the agency itself may have collective wisdom, those who are occupying seats don't necessarily have that at moment's notice. I'll also highlight that in the Senate torture report, we speak very clearly the first place we see the discussion of using coercive interrogation start is with the lawyers in the Counterterrorism Center. It doesn't come from the operators, it comes from the lawyers. Days within the attacks of September 11th, lawyers were discussing how they could allow the use of torture once the CIA had some detainees in their custody. You know, if you do a search for, quote, torture update in the Senate report, you'll see that. And the idea was, well, if we follow Geneva, then we'll just be left with question and answer, and surely we'll need more than that. So this move to do coercive interrogation techniques, to do enhanced interrogation techniques, and to do torture came not from the places you would think within an organization. It came from the legal folks who didn't engage in torture themselves or engage in even basic questioning and answering.
Susan, or anyone else who wants to join in on the second question?
Well, yeah, I think I would say again that part of the reason why this approach to interrogation based on pain and abuse occurs again and again over time is because of that belief that pain is how you make people talk, right? And so we could hope that the American public and its intelligence and law enforcement agencies would understand the science better, the psychological science that says that isn't actually how you make people tell their secrets. That might be a high bar. So I would say that what we're going to have to do is encourage the laws that are being created in a universal protocols and engaging with local law enforcement to change the culture of how we conduct interrogations. It's going to have to be done by law in lieu of a basic understanding of science.
I have one thing to add, if I may, briefly, and that comes from some of the testimony that we heard from Dr. Mitchell and Dr. Jessen in January. And I'm just going to go ahead and say part of what motivated at least the operators on the ground, a certain number of the operators on the ground, not everyone, was frankly a desire to hurt these detainees. That's just the truth of it. And you heard Mitchell and Jessen talk disparagingly about some of those operators, about people who just wanted to hurt detainees. And so that's the entire reason we have the laws that we have. That's why, to prevent that slippery slope, to prevent those people who may get lost in the moment, who may want to hurt people who they consider to be enemies of the United States, from doing that. So I just want to make sure that that's not overlooked.
David.
Yeah, I'd like to add just one thing to the first question. It didn't come out of a vacuum. If you look at news articles for the weeks after 9/11, and of course I'm doing this from personal recollection of having stood in this law school cafeteria watching the towers come down, the universal reaction was fear and rage. And within weeks, there were newspaper articles in major media saying that now the question of torture was common dinner table conversation at households all over the United States. So when you're panicked, and you don't know where the next attack is going to come, and you're furious and want to hurt the people that would do such a horrible thing, it comes to mind. I mean, and so there's a national climate that I think made it possible for officials who are charged with security to have, well, of course, if we're going to move to the dark side, we have to take the gloves off. The rules are different, and torture just comes to mind.
quick thought. I interviewed the psychiatrist, Paul Bruni, who, I'll switch to this one, who developed the list of interrogation techniques, torture techniques that Rumsfeld signs off on in December of 2002. Bernie was at Guantanamo starting in June 2002, and he told me that the 19-year-olds who were doing the interrogation right out of interrogation school at Fort Huachuca were talking about torture and pushing it, and they were citing 24, the TV program, and Alan Dershowitz, who they had seen on Fox News, and both were inspirational for them. Yeah. Were there some in the back I'm missing? No. No. Yes, go ahead. You, yeah.
Hi, thank you all for being here. My name's Shireen Khalil. I'm a journalist and also just an individual very interested in the topic. So we already had laws against this, and even without the laws, it's pretty accepted as torture is wrong. And there was no accountability afterwards. And like was mentioned before, Gina Haspel is now director of the CIA. So in a world, or a country, I should say, where we've got these very highly secretive intelligence agencies that aren't being held accountable and have the ability to classify whatever they want, how do we prevent that going forward? I know that question was sort of already asked, I'm sorry, but with no accountability, how do we prevent that from going forward? We can come up with different scientific research saying this is a better way to get this information. We can come up with laws saying this is illegal. But like you said, they just wanted to inflict pain, and so when we have these secretive intelligence agencies that are able to classify what they want and not held accountable, what else can we do?
Juan.
Yeah, well, I completely agree that accountability is a central part of prevention. And prevention is an explicit obligation under the Convention Against Torture that the United States has signed and ratified. Prevention, of course, includes several other things, but without a process of investigating, prosecuting, and punishing individual acts of torture and leading to whoever bears the highest responsibility for it, everything that we do on prevention, like human rights education, like dissemination of the Convention Against Torture, fails to achieve prevention. I don't think we should be in the belief that if we prosecute one or two, that sends a message and instantly torture doesn't happen anymore. In my own country, Argentina, a lot of torturers have been and are in jail today after receiving fair trials, and yet torture has not disappeared, much as we would like to think so. So, but on the other hand, without a process of accountability, and I mean by that criminal investigation, prosecution, and punishment of those responsible for torture, then anything we do on prevention is doomed to failure.
Does anybody else want to weigh in on that?
Yeah, I would just like to add, accountability can take many forms. I mean, some people are being held accountable in the media. And so the more, I encourage the media to report on this. I'm very delighted when I see new FOIA information come out because we are able to publicly, while it's not judicially, at least try to hold some semblance of accountability within our society if we can still operate a free press and can still go out there and find this information. And I urge everyone to dig harder because there's a lot more that you don't know.
Yes.
Hi, my name is Tahar Banani. I'm an assistant professor in Cairo University and LLM student in University of Michigan. So my question is, I would juxtapose the position of the European Court on Human Rights in terms of the Gefkin case and how they analyzed the ticking time bomb scenario with the John Yoo memorials on the justification of torture. And my question is, how does the U.S. justify derogation from the prohibition in torture, and how does the U.S. in general, the U.S.'s position in analyzing the ticking time bomb scenario in terms of international human rights law, and how does the U.S. justify this in terms of domestic law as well?
Do you want, Alka?
I mean, I can tell you what they've said in their, what the official government position is at Guantanamo in the case, which is that what happened to the defendants was not torture. That's always been their position. It's consistently been their position.
You're still taking that position now?
Yes, yes, they have defined it away, and yeah, I mean, what they will concede is that it was coercive, and so there is, and because of that, they have put in a provision in the Military Commissions Act, which is the governing statute of the Military Commissions, Section 948R, that allows for the admission of coerced evidence in the trials, so that they can get that torture-required evidence into the trial. But they only admit to coercion; they don't admit to torture.
Is there any? Oh, great. You were waiting patiently. You were, yeah, go ahead.
Hey, my name is Elise Swain. I'm a journalist with The Intercept. So, Alka, I had a question. The testimony of James Mitchell and Jessen in January at Guantanamo, it's suggesting here in the write-up that the CIA ran rival programs. So I was wondering if you could speak to that a little bit. If you can say your client's reaction, and more specifically what Jessen said, because Mitchell has been not so quiet these last couple of years, but Jessen has, and Daniel, maybe your reaction as well.
Sure, and I'll try to go quickly so Dan can. I'm sure Dan has different and probably complementary observations. But so with regards to your first question about the competing programs, this is something that emerged when we over our years-long review of some of the same documents that, of course, Dan has seen, that Mitchell and Jessen sort of proposed these techniques for use on one specific detainee, on Abu Zubaydah, in August 2002, and those techniques then migrated and were used at a site called Cobalt, codenamed Cobalt, in the Senate report, and then other sites after that. And Mitchell and Jessen themselves were not applying those techniques necessarily at Cobalt and at those other sites. Those were other CIA officials who were doing that. And so what came out in the testimony is sort of criticism from Mitchell and some from Jessen as well about the way in which their techniques, which they perceived themselves as having built in all of these safeguards as to how these techniques would be used, which are, they fall apart at the slightest questioning. But setting that aside, they took issue with the way in which these other CIA officials applied those techniques to other detainees, which of course led to, as we know, the death of Gul Rahman at Cobalt, for example, and the use of unauthorized techniques or excessive techniques on my client, on Amar, who Mitchell said was used as a test subject for certain techniques. And there was this sort of rivalry between Mitchell and Jessen on one hand and other officials who were sort of codenamed
Preacher and the new sheriff.
And the new sheriff, thank you, the preacher and the new sheriff, who were CIA officials. So, and they sort of they had what Mitchell called their acolytes, and they applied techniques certain ways, and Mitchell and Jessen didn't necessarily agree with them. There was this.
Can I risk asking Dan, who has, I'm sure knows the most on this and has, of course, the greatest constraints. And please feel free to shut me up. In his testimony at Guantanamo, and to a lesser extent in his book, Enhanced Interrogation, Mitchell talks about the characters that Alka just mentioned, the new sheriff and the preacher. And there's at least the hint or the wafting that this is kind of the tip of the iceberg of a CIA capacity that sustained itself after the 1970s, we thought, shutdown of CIA interrogation. In other words, a capacity along the lines that David Lubin and Catherine Newell have been talking about. There's a little bit of smoke there. Is there fire?
Well, in the Senate report, the declassified Senate report, the 500 pages that are out, We do talk about the chief of interrogations having been previously reprimanded for a course of interrogations in Latin America in a previous life. And there were these two programs, one that was largely run by Mitchell and Jessen, and then another that was run by this chief of interrogations who at one point called the Mitchell and Jessen interrogation program, quote, a train wreck. And then you had the other team calling the program that didn't, and by the way, Mitchell and Jessen were the only ones who engaged in largely in the waterboarding. And because this other program, they weren't allowed to waterboard, their program was considered, I believe you search for this word in the report, sissified. So there was a competing rivalry as you get in any agency that probably, the local Toyota dealership, you also got it within the CIA in this course of interrogation program. And it's also key to remember that these contractors were paid more than these normal government employees, which also causes tension. So there was a lot of just background and drama, but there were different techniques used. And in the case of Gul Rahman, the death of Gul Rahman at the Cobalt detention site, it should be noted that interrogator Jessen visited that site just days before Rahman's death, and in fact gave the CI officers there recommendations on how to treat that detainee.
There were a few hands over here before in the kind of pink shirt.
Yes, that's me. I'm in the middle of the row, so I'm just going to be loud. That'll play me less disruptive. I'm Ben Shaver. I'm a JD and MSFS student. Okay, that makes sense. I'll put it down. Okay, I'll start over.
And try to keep it quick. We want to squeeze in just a few more before a late stoppage of play here.
Yeah, so I'm Ben Shaver, JD and MSFS student. Also spent 5 years in the military doing military intelligence, 2005 to 2010, so kind of in this era. One thing that is sort of recurring throughout this whole episode is that there are a lot of people behaving badly, but the lawyers are often behaving particularly badly at particularly crucial moments. And I didn't really understand that until I got to law school, sort of how they would get there. And I do think that there's something about the way that we're trained that enables these sorts of things to be produced. And so I'm curious, particularly for the professors and the lawyers on the panel, what the legal profession has learned from this, how we can do better, where those problems are.
David.
Well, I'll just say two things. One is a former president of Yale University, who was a law professor, Kingman Brewster, said that the one thing that he learned in law school is that every position is arguable. That's one piece of the legal training. Second is what we should learn in the Code of Legal Ethics is that when somebody is giving advice to a client rather than advocating for them, the advice should not be giving the client necessarily the answer that they want. It should be candid and it should be independent. That is extremely hard for lawyers to bring themselves to do. Nobody wants to be the lawyer who says no to a client who wants to do something. Now, even though this program originated with lawyers, after a while, many government officials at the highest levels had signed off on it. And it's just very, very difficult for lawyers to live up to their ethical obligation of giving candid and independent legal advice if you think that every position is arguable.
I would just add briefly that not every lawyer fits that sad bill. And we have Alberta Mura with us. And Alberta Mura, as the Navy General Counsel, stood up courageously and pointed to a memo that he had written saying that this was torture and that he could or could not file, would or would not file, and got Rumsfeld to step back on his December 2002 list and became a heroic high-level whistleblower. And there are other lawyers who stood up as well and said no. I would voice concern as someone trained as a physician and as a psychiatrist at the failure of line psychiatrists and line other physicians within CIA to stand up. It is agonizing. Up there, you can't see it, the print's too small, but behind the tattered flag is discussion in that transcript, which comes from James Mitchell's testimony, of a physician being present during waterboarding. How in the expletive deleted did those physicians not stand up and say no? And that is a mystery. That sounds like a rhetorical question, but to me it's not. I hope to try to find that out. Yes, in the blue jacket, yeah.
Nate Christensen, George Washington University. My question is what the status of the uncharged prisoners is, and whether they have any greater prospect of being released since the agreement with the Taliban this week.
Alka, want to address that?
Yeah, that's a quick answer. There are 40 prisoners still left at Guantanamo. There are 7 in active military commissions proceedings. The rest are, 25 of them are either are eligible to be cleared for release, and there are 5 that are cleared for release. So when you say what is the status of the uncharged prisoners, they're not charged. Most of them are eligible to be released. They will likely not be released during this administration, although there was one release earlier, but that was pursuant to a deal that was brokered during the Obama administration, so that was honored. So there was one release, but that's really it.
In international law, we call that prolonged arbitrary detention.
And I think we have time for one more question. We've run out beyond the clock. Yeah, that's right.
I'm Viola Ginger with Just Security. I'm wondering, how much do we know about American public opinion about torture and about and American public awareness about these issues, and how much of these kinds of discussions are going on out there in the heartland, as they say, or outside of the Beltway, or outside of the major sort of major urban areas where this might be occurring, outside of the law schools?
Yeah. David.
The Pew Foundation has done surveys starting in 2004 on the question of should suspected terrorists be tortured often, sometimes, etc. Public support for torture has gone more or less steadily up since 2004. And there are a lot of international surveys as well, and it just turns out that the United States is near the top of the charts for pro-torture sentiment in the world. Not at the top of the charts, but in all of the surveys, we are in the top 5 pro-torture countries. I think maybe to me, one of the most significant surveys was done by the Gallup organization for the ICRC. It was a survey that was done only in countries that are actually actively engaged in armed conflicts. And it turns out that we are near the top of the charts, even among countries that are engaged in armed conflicts. The explanation is, we don't have time for me to get started on that, but I just want you to be aware of that fact. And public support for torture crossed the 50% mark in 2014.
Greg, can I add something here from Darius Rajali's part of the book? What he looked at and analyzed was the fact that it's a partisan issue. Among Democrats and Republicans, both equally oppose torture. After Obama had his policy of impunity, we'll look forward, not backwards, more Republicans started to support torture more. So whether that was linked to accountability or not, but we've seen a groundswell, particularly among Republicans, since that time, that are more supportive of torture than Democrats or independents.
Just a real quick add on that. Keep in mind, as well as with the Senate documents and their report, is a systematic effort by the CIA to convince people that torture was effective after 9/11, and that was largely an effort to avoid accountability. So you see these individuals who led the CIA who are still on television today. We talked about lack of accountability in terms of a legal sense, but there's also not a societal accountability on these folks who have misled and continue to lead the American people and the world.
As we wrap up, I just offer this brief reminder, especially in the face of the folks that Dan just mentioned. We're often invited by the folks who are not opposed to these techniques to see rejection of torture and rejection of abuse as somehow sympathy with Al-Qaeda or ISIS, with people who planned the 9/11 attacks, etc. And I think it's worth us all remembering what I hope most of us understand as the obvious, that this is ultimately not about them, not about what many believe that they did and what they may have done. This is about us, who we are, who we aspire to be, how we wish to be treated should the tables ever be turned. And that's often hard to forget in frenzies of outrage after something awful is done to us, but it is worth remembering. And I thank our panelists. I especially thank Dan and Juan, and I thank all those here at Georgetown who set up and made this event happen. And go home and be safe. Thanks so much, everybody, for coming. Oh, there is a reception with food. I hear it might even be good.
Wow.